David, sweetheart. Loves, buckle in, because what just detonated inside that Los Angeles courtroom is not a hearing anymore. It is a slow-motion execution of a career, a reputation, and possibly a life sentence, and if you have been following this case for even 1 week, you already know today's session cracked the entire foundation of the D4vd defense wide open. Fake blood in the garage. A blue plastic pool that fits together like a jigsaw puzzle of horror. A missing chainsaw that nobody can locate. A phantom phone call placed to a dead girl. A reporter dragged out of the room by the judge. A private investigator ejected before he could ever take the oath. And a defendant who sat there, arms folded, styrofoam cup of water in front of him, staring straight ahead as the prosecution laid out the most damning single day of testimony this case has produced. This is day 3 of the David Anthony Burke preliminary hearing, and after what dropped in that morning session, the chatter behind the scenes says the defense team is now, quietly, in absolute panic. Because when a criminalist walks into a courtroom holding pieces of a pool that fit into the plastic embedded in a 14-year-old girl's decomposed remains, you do not need a jury to feel the temperature in the room. You need a witness. And today, D4vd got 8 of them. Loves, this is the day the case turned. And I am walking you through every single second of it. Now, pause. Rewind. Let me set the table properly, because if you are just tuning into this nightmare, you need to understand exactly what the state of California is accusing this young man of. David Anthony Burke, known to the world as the singer D4vd, stands accused of the sexual abuse, the first-degree murder, and the unlawful mutilation of the remains of Celeste Rivas Hernandez. Celeste was 14 years old. 14. She had a name, she had a family, she had a mother named Mercedes who is sitting inside that courtroom right now watching photographs of her daughter's leggings, cut apart at the kneecaps, being displayed on a courtroom projector. Celeste's dismembered, decomposed remains were pulled out of the front trunk of a Tesla in Los Angeles in September of last year, and that Tesla was registered to D4vd. Those are not allegations pulled out of nowhere. Those are the facts the prosecution is stitching together, one witness at a time, to convince a judge there is enough probable cause to move this thing to a full-blown trial. And Loves, based on what has spilled out into that courtroom over the last 3 days, I do not see how this judge does anything but greenlight it. This case is not walking to trial. This case is sprinting to trial. And D4vd is sitting in the front row watching it happen. Let's start where the day started, with the judge losing her patience before the first witness even took the stand. Because day 3 did not open with testimony. It opened with fireworks. A reporter, I am not going to name her, because she has already been publicly dressed down, was ejected from the courtroom this morning. Ejected. Kicked out. Removed. The judge cited a violation of the live transmission rules that have been ironclad from the moment this case entered the system. No cameras. No phones. No devices. No transmissions to the outside world. This courtroom has been sealed like a vault, and for good reason, because everyone in that building, from the deputy DA down to the sketch artist, understands one thing: if a single piece of this case leaks improperly, the defense will scream mistrial before the ink dries on the transcript. And the judge is not letting that happen. Not today. Not tomorrow. Not on her watch. So when a reporter allegedly transmitted something she should not have, the judge did what strong judges do, she made an example, and she made it fast. Removed. Done. Next. And Loves, if that is how the judge handles a reporter over a transmission rule, imagine how she is going to handle any defense stunt at trial. This is a courtroom running on a very tight leash, and the leash is being held by a jurist who does not blink. But that was not the only person hauled out of that courtroom. Because right after the reporter, the deputy district attorney, Beth Silverman, who has already established herself as one of the most surgical prosecutors in Los Angeles County, stood up and requested the exclusion of Steve Fisher, the private investigator who has been all over this case since the Tesla was towed in Hollywood back in September of 2025. Steve Fisher, if you have been following this saga, is the PI who was hired by the owner of the property where D4vd had been staying. He has been on every legal show, every podcast, every live stream, dropping breadcrumbs about what he says he uncovered near the scene. But this morning, the prosecutor accused Fisher of violating grand jury secrecy, and the moment she raised the issue, Steve Fisher stood up in his seat, acknowledged the request without a word of pushback, and walked out. No fight. No objection. No defense. He simply left. Which means Fisher will not be called as a witness in this preliminary hearing. If this case moves to trial, and it is moving to trial, expect his name to reappear at the top of a witness list. But for now, he is out. And that is 2 people gone from the room before 9:30 in the morning. 2 ejections. 1 judge. 0 patients. This is not a hearing. This is a demonstration of institutional force. And it set the tone for every single thing that came after. And through all of it, through the ejection, through the exclusion, through the parade of forensic exhibits, D4vd sat there. Not moving. Not reacting. Not writing. Not blinking. The courtroom sketch artist, Mona Schaefer-Edwards, described him during the break using one line I cannot get out of my head. She said D4vd looked like he was, quote, on another plane. On another plane. That is a woman who has drawn defendants in Los Angeles courtrooms for decades. She has sketched murderers. She has sketched celebrities on trial. She has watched men and women who understood, in real time, that the rest of their life was being decided in front of them. And she said this young man looks completely disengaged. Not scared. Not remorseful. Not defiant. Just absent. Arms folded. Yellow legal pad in front of him with nothing written on it. Styrofoam cup of water. 2, maybe 3 brief mumbles to his attorneys over the course of an entire morning. And when the prosecution displayed photographs of Celeste's soiled, blood-stained, insect-infested clothing, the leggings cut apart at the knees, the little socks, the underwear, D4vd stared straight ahead as if he were watching paint dry. Loves, I am not a psychologist. I am not going to sit here and diagnose this man on YouTube. But I will tell you what every legal veteran watching this case is whispering right now, and the whisper is one single word: medication. Because a 21-year-old singer facing capital-eligible charges does not sit like that in a courtroom unless something is helping him sit like that. And if that comes up at trial, it will come up loudly. Because a defendant who cannot visibly react to the evidence against him is a defendant a jury is going to study very, very closely. Now, the substance. Because as fascinating as the courtroom theater is, the real weapon dropped today was forensic. And it dropped in layers. The first witness back on the stand was the LAPD criminalist who processed the evidence recovered from D4vd's garage, and I mean everything. Trash bags. Rubber floor mats. Blood stains. Chainsaws. And this is where the defense attorney, Blair Burke, started swinging hard. Burke went after the criminalist on the chainsaws, because there were chainsaws in that garage. Multiple chainsaws. And Burke's angle was this: if these chainsaws were the weapons used to dismember a human being, why was there no positive blood test on them? Why weren't they taken into evidence? Why weren't they tested for touch DNA? Why weren't they treated as the murder-adjacent artifacts they would obviously be if the state's theory is correct? And loves, this is where the defense is trying to build a doorway wide enough to walk reasonable doubt through. Because if you can convince a jury that the tools the prosecution is pointing at were never actually used, you crack the dismemberment narrative. And if you crack the dismemberment narrative, you crack the cover-up narrative. And if you crack the cover-up narrative, the whole architecture of the case starts to wobble. This is defense lawyering 101, you do not attack the mountain, you pull one stone out at a time and hope the summit collapses. But here is what the defense may not have counted on. The criminalist did not flinch. Not once. She calmly explained that when the initial presumptive test on the chainsaws came back negative, meaning no indication of blood, there was, in her professional judgment, no forensic value in seizing them. She testified that if those chainsaws had been used for dismemberment, there is no cleaning process on earth thorough enough to erase every biological trace from a presumptive field test. In other words, she looked the defense in the face and said, if these were the murder weapons, we would have known. And that is why they stayed in the garage. But, and hold up, loves, because this is the part that made every legal analyst watching this case sit up straight, there is another chainsaw. A third chainsaw. A Makita brand chainsaw that was ordered online, shipped to D4vd's residence, and, as of the state of the evidence presented in court so far, never located. Missing. Gone. Vanished. And that chainsaw, loves, is the one they cannot rule out. That is the chainsaw the prosecution is going to build a mountain on when this thing reaches trial. Because you cannot testify that a tool did not commit a crime when you cannot find the tool in the first place. And a missing chainsaw in a dismemberment case is not a loose end. It is a red flare. It is a screaming, blinking, siren-loud piece of missing evidence that any prosecutor worth their salary is going to weaponize in front of a jury. And then came the wipes. Because the criminalist also testified that inside the garage, LAPD located a double-bagged trash bag. 2 black plastic bags nested inside each other. And inside the interior bag, they found white wipes, described in court as Clorox-style cleaning wipes, stained a brownish color. And when those wipes were tested, they came back presumptive positive for the possible presence of blood. Now, pump the brakes. A presumptive positive is not a confirmed identification. Additional testing is required to lock down whether that is human blood or something else entirely. But the picture the prosecution is painting is not subtle. It is not sophisticated. It is not even trying to be. It is a wall poster. Someone bought cleaning wipes. Someone used those wipes to clean up something dark. Someone double-bagged those wipes and threw them in the garage where a human being was allegedly dismembered. You do not need a chemistry degree to follow that line. And you do not need a law degree to understand that when a jury sees those bags, and hears the phrase presumptive positive, the presumption that is going to form in their minds is not innocent. Now, moving right along, because this is where the day escalated from damning to devastating. The next witness was another LAPD criminalist, Lisa Leonardo, and Lisa Leonardo did something in that courtroom today that, in my honest legal opinion, was the single most cinematically annihilating piece of forensic testimony in this entire preliminary hearing. She brought the pool. Loves, if you have been following this case, you already know the pool has been a haunting undercurrent from the very first charging document. A blue inflatable pool. Purchased. Delivered. And, allegedly, used. Today, Lisa Leonardo walked the court through her forensic analysis of that pool, alongside evidence transferred to her from the Los Angeles County Medical Examiner. That evidence included bits of blue plastic that were pulled out of Celeste's remains during her autopsy. Blue plastic embedded in the body. And Lisa Leonardo, sitting on that witness stand today, testified that she took those bits of blue plastic, the ones removed from a 14-year-old girl's dismembered remains, and she reconstructed them, under a microscope, back into the blue inflatable pool that came out of D4vd's garage. They fit. They fit like a jigsaw. Exhibit photographs were shown to the court demonstrating the physical match. Linear cuts identified on the pool. 4 areas of damage catalogued. And the pieces from Celeste's autopsy slotted back into those damaged areas like they had never left. Loves, I am telling you, when that testimony landed, you could feel the oxygen leave the courtroom. Loves, I am going to say this once, and I am going to say it plainly. If you are on that defense team and you have just watched a forensic scientist reconstruct your client's inflatable pool using plastic pulled out of the victim's body, you do not have a defense anymore. You have a plea negotiation. Because a jury does not need to be a forensic expert to look at those photographs and understand what they are seeing. They are seeing the pool. They are seeing the girl. And they are seeing the girl in the pool. That is the moment this case became irreversible, and every legal veteran I have spoken with in the last 2 hours agrees. Trust me on this, the puzzle fit of that pool is going to be the exhibit that lands this case in front of a jury, and the exhibit that closes it once it gets there. Because there is no innocent explanation for how microscopic pieces of a specific inflatable pool that lived in a specific defendant's specific garage ended up embedded in the specific dismembered remains of a specific 14-year-old girl. There is no coincidence that survives that math. There is no alternative theory that survives that math. That is the exhibit. That is the case. That is the smoking gun in plastic form. And through all of that, through Lisa Leonardo's testimony, through the photographs, through the reconstruction, Celeste's family was in the room. Her family walked in this morning around 10:30. They were not there for the opening bell, but they were there for the pool. Her mother, Mercedes, who broke down on day 1 when the contents of the cadaver bags were displayed on screen, sat in that courtroom today watching photographs of her daughter's Skechers brand socks, her underwear, her leggings cut at the kneecaps because, allegedly, her legs were severed at the joints. Mercedes did not react today. Not visibly. Not the way she did on day 1. Reporters in the room described her as frozen. And loves, if you have never watched a mother sit through the forensic reconstruction of what someone did to her 14-year-old daughter, I hope you never have to. Because the silence of a grieving mother in a courtroom is louder than every piece of testimony combined. It is the loudest thing in that room. And it will be the loudest thing in every juror's memory if this case reaches trial. Because a jury is going to remember one face when they retire to deliberate, and that face is not D4vd's. That face is Mercedes. Which brings me, inevitably, to the question every legal analyst has been asking privately for weeks. Why is the prosecution presenting this much? Because this is a preliminary hearing. The standard is probable cause. That is a low bar. The state does not need to prove guilt beyond a reasonable doubt at this stage, they only need to convince a judge there is enough smoke to justify a full trial. So why parade Lisa Leonardo up there with the pool? Why show the socks, the leggings, the plastic from the autopsy? Why put Mercedes through this? Loves, I have a theory, and the theory is not complicated. The prosecution is not just building probable cause. The prosecution is sending a message. The message is to the defense. The message says, this is what we have. This is what we will show a jury. This is what will be on every screen in that trial courtroom for weeks. Do you really want to walk your client into that room? Or do you want to talk about a deal? Because California has the death penalty on the table for this case. And if the deputy DA is willing to signal, very quietly, very professionally, that the death penalty could come off in exchange for a plea, this is exactly how you signal it. You show the pool. You show the socks. You show the mother. And you let the defense do the math. This is not overkill. This is a negotiation, dressed up as testimony, delivered in front of a judge who understands exactly what she is watching. Now, hold up, because I promised you digital evidence, and this is where the case turns from forensic into forensic plus electronic. Because today the LAPD digital analyst testified. And the testimony he delivered essentially closed the geographic loop on this entire narrative. Loves, I want you to understand what happened, because when I first read the charging documents on this case months ago, I had one question I could not shake: why in the world would a suspect drive his own Tesla to commit or cover up a crime? A Tesla. A vehicle that is essentially a rolling data recorder. Every acceleration, every steering input, every latitude and longitude down to the meter, logged. Uploaded. Preserved. And on top of that, why bring your own iPhone? Because between the Tesla and the iPhone, you have essentially two independent witnesses that never stop testifying. Two silent witnesses that talk to investigators long after the driver has gone quiet. That is the reality of committing a crime in 2025. Your car snitches. Your phone snitches. And no lawyer on earth can cross-examine a data log. And today, LAPD walked the court through both. The digital analyst pulled up maps in open court showing the Tesla's route on the night of April 23 and into the morning of April 24, 2025. From the Hollywood Hills, westbound along Sunset Boulevard, then north up the California coast into Santa Barbara County. And overlaid onto that route, line for line, minute for minute, was the geolocation data pulled from D4vd's personal iPhone. Same route. Same timestamps. Same coordinates. The car and the phone traveled together. And the endpoint of that route, the terminus, was Lake Cachuma, off State Road 154 in Santa Barbara County. Which is exactly where Celeste Rivas Hernandez's passport card was later recovered. Loves, if you were writing this as a courtroom drama for streaming television, an editor would send it back with a note that said, "This is too neat, make it messier." But this is not fiction. This is data. And data does not care about how neat it looks. Data is not sympathetic. Data does not lie for a friend. Data does not take the fifth. Data just is. And the data in this case has been talking for months. And it gets tighter. Because the analyst testified that both the Tesla data and the phone data show additional trips north to Santa Barbara County after that first drive on April 24. Multiple return trips. Which means whoever was driving that Tesla, and whoever was carrying that iPhone, kept going back. Back to the same area. Back to the region where a young girl's identification would ultimately be found in the dirt. You do not go back to a scene like that once and then never again unless the location has meaning. And the prosecution's theory is that the location has meaning because the location is where evidence was disposed of. Repeatedly. And loves, I want you to sit with that. Because the state is not just alleging one bad night. The state is alleging a pattern. The state is alleging return visits. The state is alleging the kind of behavior that only makes sense if someone was cleaning up something in stages. And if that theory survives cross-examination, this case moves from probable to overwhelming. And then there was the phone call. Loves, the phone call. Because after the Tesla got onto the road heading north on that April night, somewhere between 30 minutes and an hour into the drive, the analyst testified that a call was placed. An outgoing call. From D4vd's phone. To Celeste's phone. Now, the defense objected immediately. And the objection was sustained. Because the defense wanted the court record to reflect very carefully that the LAPD detective is not testifying that D4vd personally made that call. The detective is testifying that the phone associated with D4vd made an outgoing call to the phone associated with Celeste. That distinction matters legally. But loves, let's be human for a second. If the prosecution's theory is correct, if Celeste was already deceased inside that Hollywood Hills residence when the Tesla left the driveway, then whoever was holding that phone knew that call would not be answered. The phone would ring into the void. Nobody would pick up. Because the person on the other end could not pick up. And in the prosecution's framing, that call is not a call. It is a cover story. It is a digital breadcrumb designed to establish an alibi, the appearance of a normal call from a boyfriend to a girlfriend on a normal night, placed at a moment when the caller was, allegedly, driving her remains to a lake. That is not just damning. That is theatrical. That is a phone call designed to be found. That is a phone call designed to say, see, everything was fine, we were still talking, she was still alive. And a jury is going to see straight through that if the state can tie the timeline together. Now, the question every seasoned legal analyst has been asking. Where is the evidence of the actual murder? Because the state has spent 3 days building a mountain of evidence about cleanup. About cover-up. About dismemberment. About disposal. About digital movement. But where is the evidence that D4vd killed her? Where is the moment of death? Where is the direct proof that Celeste Rivas Hernandez was murdered as opposed to, for example, dying from some other cause, and the defendant panicking and covering it up? Because a jury is going to ask that question. Loves, the honest answer as of the morning session of Day 3 is, the prosecution has not yet presented that piece. This is a circumstantial case. Every incriminating Amazon and Home Depot purchase, the burn cage, the fireproof mats, the chainsaws, the body bags, the trash bags, every single one was made after April 23rd. After the alleged killing. Which is powerful evidence of consciousness of guilt, but it is not evidence of the killing itself. There is no home security footage of the moment. There are no eyewitnesses inside that home. There is not, so far, a text message thread between D4vd and Celeste in the hours before her death that has been introduced. And this is the gap in the prosecution's case, the space between the ending and the aftermath. But here is what I would watch for, because the medical examiner has not yet taken the stand. Dr. Oduko, the LA County medical examiner leading this case, has been under a court-issued gag order since last fall. LAPD filed a motion to place additional autopsy details under seal. Which means the coroner's most explosive findings, cause of death, manner of death, the specific mechanism of the killing, have been locked in a sealed file for months. When Dr. Oduko finally testifies, and my understanding is that testimony is coming soon, that is when the prosecution will attempt to fill the gap. If the medical examiner testifies to 2 penetrating stab wounds, if he testifies that the manner of death is homicide by sharp force trauma, the circumstantial case suddenly acquires a spine. And if the state can then match that testimony with text messages between D4vd and Celeste in the hours before her death showing conflict, threats, jealousy, or a fight, this case flips from strong circumstantial to overwhelming. That is the pivot point every legal analyst in Los Angeles is waiting for. And it may be less than 24 hours away. And now, loves, let me tell you what the defense tried to do today, because they are not sitting on their hands. Blair Burke is not that kind of attorney. She is one of the sharpest defense lawyers in Los Angeles, and she came in swinging with an alternative theory. And the alternative theory dropped for the first time today, a new narrative, a new doorway, a new attempt to inject reasonable doubt. If you have followed D4vd's music career online, you have seen the visuals. You have seen him in white t-shirt stained with what looks like blood. Fake blood. Music video blood. Merchandise blood. Today, the defense revealed, for the first time on the record, that LAPD criminalists actually found jugs and jars of fake theatrical blood inside D4vd's garage. Fake blood. And the defense argued that D4vd's garage was not just a residential space, it was, in effect, a merchandise workshop, where t-shirts and sweatshirts were being produced and stained with theatrical blood as part of his music brand. LAPD forensically tested the substance. It came back negative. Not human blood. Not blood at all. Which meant it was not taken into evidence. But Loves, the defense has now planted the seed. And the seed is this: if there is fake blood in this garage, then some of the alleged blood-adjacent evidence in this case has an innocent explanation. It is not a full defense. It does not explain the pool. It does not explain the trip to Lake Cachuma. It does not explain the missing chainsaw. It does not explain the Amazon receipts. It does not explain the phone geolocation. But it is a foothold. And a good defense attorney only needs one foothold to sell a jury on reasonable doubt. And this is the pattern I want you to notice, Loves, because it is elegant defense work. Blair Burke is not trying to win this preliminary hearing. She knows she cannot win a preliminary hearing where the standard is probable cause and the state has this much circumstantial evidence. She is trying to lose the preliminary hearing in a very specific way, a way that leaves as many alternative explanations on the record as possible, so that when this case actually reaches trial, she has a library of doorways to walk through in front of a jury. The fake blood angle is doorway number 1. The missing chainsaw as a defense-favorable ambiguity is doorway number 2. The absence of direct murder evidence is doorway number 3. She is stacking doorways. She is building a maze. And she is banking on the possibility that at trial, 12 jurors will get lost in that maze long enough for at least one of them to say the two words every defense attorney lives to hear: reasonable doubt. And that is exactly what makes this case so dangerous, and so watchable. Because on paper, this case looks airtight. Pool fragments in a body. Digital breadcrumbs from a car and a phone that traveled in lockstep. Cleaning wipes with presumptive blood. A missing chainsaw. Purchase histories that read like a shopping list for a crime scene. A defendant sitting silently as it all unfolds. And yet, the defense is going to argue theatrical merchandise. The defense is going to argue no direct evidence of the killing itself. The defense is going to argue circumstantial. The defense is going to argue that a 21-year-old singer with a music brand built partially around dark aesthetics was targeted by an investigation that assumed guilt before it confirmed guilt. Whether that argument survives contact with a jury, that is what a trial is for. And Loves, that is a trial the state is now actively daring the defense to walk into. And Loves, mark my words, this is only beginning. Because we still have day 3's afternoon session. We still have day 4. We may have day 5. We still have the medical examiner. We still have the possibility of additional digital forensic experts. We still have the Amazon and Home Depot custodian testimony. We still have, potentially, additional witnesses who spent time inside that Hollywood Hills residence in the days after April 23. Every single one of those witnesses is a new line of testimony that either tightens the case or gives the defense another crack to widen. And the Deputy DA, Beth Silverman, is not the kind of prosecutor who saves her best evidence for later. She is the kind of prosecutor who builds a wall of testimony so high that by the time she rests, the defense is looking up at it wondering how they are supposed to climb over. She does not do subtle. She does not do minimum. She does maximum. And she has been doing maximum for 3 straight days. Now let's talk about D4vd himself for a moment, because his behavior is starting to raise questions that go beyond the courtroom. Since his arrest, D4vd's musical career has effectively frozen in place. His label has gone silent. Streaming platforms have quietly reduced his front-facing placement. Collaborators from earlier in his rise have scrubbed their social media of joint appearances. And Loves, that is not an accident. That is the entertainment industry doing what the entertainment industry always does when a young signed artist is charged with something this severe. It disappears him. Not officially. Not with a press release. Just, quietly. His name stops appearing in playlists it used to headline. His previous single, the one that gave him his breakout moment, has been slowly deprioritized on algorithmic recommendation systems that 6 months ago were pushing him to the top of new listener queues. The machine that built D4vd is now unbuilding him in real time. And if this case ends in a conviction, that unbuilding becomes permanent. His masters will still exist. His publishing catalog will still exist. But the artist known as D4vd, the persona, the brand, the presence, will effectively cease to be marketable. Ever again. And now, loves, let me tell you the piece the mainstream coverage keeps skipping. Because there is a broader context around this case that a lot of people are not talking about, and I think you deserve to hear it. Celeste Rivas Hernandez was 14 years old. She was a minor. She was, according to court filings and reporting, in some form of relationship with D4vd, a young man in his 20s, a signed and touring recording artist, a man with resources, a man with a home in the Hollywood Hills, a man with a legal team, a man with public visibility. That imbalance is not incidental to this case. That imbalance is at the core of this case. Because the prosecution's theory suggests that D4vd may have killed Celeste to prevent her from exposing him. Exposing him for what, the prosecution has hinted, but has not yet argued in full. And this is where the case is going to get much bigger than one alleged crime in one Hollywood Hills residence. Because if the state's theory is that Celeste was going to reveal a relationship, an incident, a pattern, and if a 21-year-old signed artist chose to end a 14-year-old girl's life to prevent that revelation, this case becomes something more than a murder trial. It becomes a referendum on how much protection young girls receive in the modern entertainment industry when they end up in proximity to men with money, fame, contracts, and lawyers. And that referendum is one this entire industry has been dreading for years. Because the industry knows what its own back rooms look like. And the industry knows that any high-profile trial that shines a light on those back rooms is a threat. Loves, I want to say something plainly, because I have been thinking about it all morning. Celeste Rivas Hernandez was somebody's daughter. She was a 14-year-old girl who liked things. Who wore Skechers. Who had a favorite pair of leggings. Who existed in the world with a family that loved her and a future that stretched in front of her. And whatever happened to her, whatever the state ultimately proves happened to her, she did not deserve any of it. Not 1 second of it. And I want to be extremely careful, as this case moves forward, that in the noise of forensic testimony and digital data and courtroom drama, we do not lose sight of who this case is actually about. This case is about Celeste. Not about D4vd. Not about his career. Not about his lawyers. Not about the theater of the courtroom. Celeste. Her name. Her memory. Her family. Everything else is just how the state gets to justice for a child who cannot speak for herself anymore. That is what this is. That is all this is. So here is the fork in the road, loves. And I want your honest verdict in the comments, because I read every single one. Do you believe, based on the evidence presented over 3 days of this preliminary hearing, that the prosecution has already established more than enough to send this case screaming into a full-blown trial? Do you believe the pool alone, that jigsaw-fit reconstruction of blue plastic pulled from a child's remains, is the single exhibit that ends this defense's ability to negotiate? Or do you believe the defense's new fake blood, music merchandise theory will survive cross-examination and give a jury enough reasonable doubt to force a hung outcome? And here is the harder question. Should California pursue the death penalty in this case if a conviction lands? Or does keeping the death penalty on the table give the prosecution the leverage they need to force a plea that spares Celeste's family the trauma of years of appeals? These are not easy questions. These are not hypothetical questions. These are the questions being whispered in the hallway of that Los Angeles courthouse right now. And they are the questions that will define what justice looks like in this case for the rest of our lives. The chatter behind the scenes says the medical examiner may take the stand as early as tomorrow. When Dr. Oduko opens his mouth, this case will change again. The autopsy details that have been sealed for months are about to spill into the public record. Manner of death. Cause of death. State of decomposition. Sharp force analysis. All of it. And whatever he says, one thing is certain. That testimony is going to be the moment David Anthony Burke finds out whether his life is over, or whether he still has a fighting chance. And I will be here for every second of it. Loves, if you have followed this case with me from day one, thank you. If you are new to this case and just tuned in, welcome, and buckle up, because we are not close to done. Subscribe. Turn on the notifications. Drop your verdict in the comments. I am reading every single one, and the smartest comments will make it into tomorrow's breakdown. Trust me on this, when the medical examiner takes that stand, you do not want to miss what happens next. Because the floor is about to fall out. And the whole courthouse is going to feel the tremor. I will see you tomorrow, loves. Same seat, same coverage, same commitment, to Celeste, to her family, and to the truth.